We now come to the last part of our today discussion, and that will be on the topic of concepts of proof in large construction disputes. And the speaker will be Mr. Julian Bailey. Perhaps I just introduce the short bios of Julian. He is a partner in the London firm of White & Case, practicing in the firm's international arbitration and construction and engineering groups. He advises on international construction and infrastructure projects across a variety of industries. He has been active in relation to projects on most continents, representing governments, developers, and contractors in large construction and engineering projects and disputes. Julian is also actively involved in construction law issues and was chairman of the Society of Construction Law. He is also the author of the famous book of Construction Law, London Publishing Partnership, and the third edition, 2020. So with this introduction, now we see Julian on the video. So I'll pass it to Julian so that we can understand from him about the concepts of proof in large construction disputes.
Well, thank you very, very much indeed, and thanks for that kind introduction. I hope my slides are visible.
Yes, at the moment we haven't seen the slide, but that will be shown quick. Yes. Okay,
are they showing?
Yes.
They are, okay, great. The one thing I can't do is put them in slide share mode, so if you can bear with me, that will be okay. This is the function of my computer at this point in time. So what I'm going to be talking about is a very broad topic, concepts of proof in large construction disputes. And I have a very loose structure for my presentation too. You might even say I have no structure at all, which is unusual. But if we're looking at things, perhaps we can look at things in a linear sense in relation to evidence in construction engineering projects. And to do this, I want to go back in time to the late 18th century, to a case of Folkes and Cho, which is a seminal case in construction law and in the law of evidence. This case is about a port in England, in North Norfolk. The port is called Wells. In fact, I was actually there last week on my little summer break. You can see a picture of it there. And so it's on the coast. And a feature of this area is that there are rivers that flow into the port, into the harbour there. And what this can do is lead to the harbour silting up over time. Now, the issue in this case was because Mr. Folkes, who was the plaintiff, was a landowner nearby, and he built an embankment around his land to stop the land from flooding. He had cattle and things like that, and he didn't want the land to flood. And this embankment was right on the harbour. Now, over time, the harbour silted up, and this was a big problem for the Port Authority there in Wells. And they pointed the finger of blame for this to Mr. Folkes. They said, well, you built this embankment. The harbour's now silting up. Your embankment is causing the harbour to silt up. So we want you to remove the embankment. And in fact, they started to tear down the embankment themselves. They obviously felt very strongly about it. And Mr. Folkes, who was actually a barrister, he brought court proceedings in relation to this to stop the harbour commissioners from tearing down his embankment. And the issue in the case turned on what was causing the harbour to silt up. Mr. Folkes said, well, it just happens naturally, whereas the harbour commissioner said, well, it's your embankment that's causing the harbour to silt up. And what Mr. Folkes did was he called a person as a witness for him. And this person was an engineer, but not just any engineer. It was John Smeaton, known these days as the father of civil engineering, and he had vast experience in relation to maritime projects, particularly on the coast of England, and also in relation to the North Norfolk coast. And Mr. Smeaton's evidence was that in fact the harbour was silting up, not because of the embankment, but because of the flow of silt from the local rivers into the harbour. The issue in this case, which may seem remarkable to us today, was actually whether his evidence should be admitted before a jury. Why might that be an issue? Well, because back in the day, the only people who could give evidence about matters, civil matters, were the people who were eyewitnesses, the people who were involved. And he was not there. He couldn't attest to why the harbour was silting up. But yet he was a person of expertise. He might be able to express an opinion about this. And the question was whether his opinion could go before a jury. And the case was decided eventually in a very conclusive way, and an important way for us. The leading judgment of the court was given by the great Lord Mansfield, one of the greatest judges in English history. And he said that Mr. Smeaton's evidence was admissible before a jury. So he said the cause of the decay of the harbour is also a matter of science. So he's referring to scientific matters here. Of this, such men as Mr. Smeaton alone can judge. Therefore, we are of opinion that his judgment, formed on facts, was very proper evidence. And Lord Mansfield then says, I cannot believe that where the question is whether a defect arises from a natural or an artificial cause, the opinions of men of science are not to be received. So that's his way of saying that this scientific evidence was to be put before a jury. And so this case is a seminal case because it opened the door to expert evidence being admitted in civil cases, whereas previously this was not established. But what did this mean then? Well, what it meant at the time was that the evidence of Mr. Smeaton could go before a jury. So Mr. Smeaton was a scientist, and his scientific evidence could be put before a jury. But what does a jury then do with that evidence? Well, the jury can do a number of things, but they come to a decision. And in this particular case, they had to come to a decision as to the cause of the harbour falling into decay. So it wasn't necessarily a scientific decision, and they didn't have to give any reasons for their decision. They just had to answer the question, what was the cause of the harbour silting up? So we go from what evidence which may be scientific and precise even being put before a jury, and the jury may make a fairly imprecise decision, but it could still be a correct decision in any case. And where does this lead us? Well, I think it leads us to how English law tackles evidence in civil cases. And this is important even now, of course, to construction and engineering cases. So the standard of proof which is applied in civil cases is what we call the balance of probabilities. So this means that if one can show there's a greater than 50% chance of a key fact being true, then you have proven your case. So that's a fairly low threshold, really. So it's more likely than not that something occurred, and you might win your case. Now, English law has taken this approach largely for pragmatic reasons, because it's difficult, particularly with juries, to adopt a more precise or higher threshold, certainly in civil cases. So if we just come back to the case of Folkestone Chad, how might this work in practice? Well, let's say Mr. Smeaton said, we don't know what his evidence was, but let's say he said there was a 60% chance that Wells Harbour had silted up due to the local rivers. If the jury accepted this, as the jury would be entitled to, they could say, well, on the balance of probabilities, there's a greater than 50% chance that the harbour silted up because of the rivers and not the embankment. Therefore, they could have delivered a verdict in favour of the landowner, Mr. Folkes. So really what I'm contrasting there is how we have this rather imprecise, yet slightly mathematical way of expressing our standard of proof in civil cases, which applies to the cases that we deal with. And if we move forward in time by about 150 years or so, we can see how this idea developed, and it's still a bit fuzzy in the early to mid 20th century. And I've got a quote here, and this is from an Australian case that went to the Privy Council, Grant and Australian Knitting Mills, which is actually about a poor gentleman in Adelaide, my home city, who bought some undergarments which gave him dermatitis. And the issue in this case was what caused the dermatitis. Was it the garments, or was it something else? But in giving the opinion of the Privy Council, Lord Wright, who you see there, a man who was never wrong, he was always right, said mathematical or strict logical demonstration is generally impossible. Juries are in practice told that they must act on such reasonable balance of probabilities as would suffice to determine a reasonable man to take a decision in the grave affairs of life. Pieces of evidence, each by itself insufficient, may together constitute a significant whole and justify by the combined effect a conclusion. So what you can see here is again this fuzzy approach that is taken to evidence in civil cases, looking at the balance of probabilities, and we must remember that civil cases historically were put to juries. That practice has largely died out, apart from in certain parts of the United States. But fact finders were generally people of the jury, and they would make their decision on the balance of probabilities, which in their minds would just involve weighing up everything before them and asking, well, is the conclusion that the plaintiff is seeking more likely than not? And that was it. And that was a pragmatic measure. And we need to understand that there's a large measure of pragmatism that has applied and still applies in how the common law treats evidence. So that's background. Now let's go from there to a more modern context, to where we are today. So many of us are faced with large construction disputes, maybe relating to very large infrastructure projects in particular. And what can this lead to? Well, I think it can lead to what I call claims overload, where we feel we're being deluged with information. And why is this? Well, there are many reasons for this. On large projects, there could be thousands of different claims, thousands of variations, perhaps thousands of defects claims, thousands of drawing submittals and comments on those drawings, hundreds of extension of time claims. So on the project itself, there could be numerous things that give rise to numerous disputes. And if we look at the volume of information that is out there, well, of course, we have hard copy information, but these days we have electronic information, which seems to even outnumber by several factors the amount of hard copy information that we have. So lots and lots of information to deal with, and we might be talking about claims that are worth hundreds of millions of dollars or even billions. So these are big claims on big projects where there's a lot of information to deal with. And so the challenge for us and for the law is how we deal with these claims in these large projects. And what I want to do now is just go through some of the emerging trends, if you like, in relation to dealing with larger claims. But let's look at the starting point, if you like, which is conceptually, how does the common law approach claimants or plaintiffs making claims, where the claim is actually contested? The starting point really is that it is for a claimant to prove its case on the balance of probabilities. So the claimant must adduce evidence to demonstrate that in respect of each of its claims on the balance of probabilities, the key facts are there and the decision maker can decide in favor of the plaintiff. But what if there are, as I mentioned, cases like where you have hundreds or even thousands of claims, such as defects claims, and maybe some of these are of smaller value? Or to see how the common law courts have tackled these issues in a more modern context. I'll start with a case from New South Wales. This is the case of HSH and Multiplex, which is about an apartment building in Kent Street in Sydney. This is the Stanford apartments. Some of you will know these apartments. When it was built, the owner, HSH, said, actually, we can't take possession of the building. We can't use it because there are so many defects. And they brought this case saying that there were 16,000 or so minor defects, which prevented them from taking over the building and using it. And so the case went to court, and experts were called. The defects expert for the hotel was a gentleman by the name of Richard Nixon, surprisingly, who gave evidence in relation to all of the defects, all 16,000. And the expert for the contractor was a fellow called Mr. Johnson, who was not cross-examined on all of Mr. Nixon's evidence regarding the 16,000 defects. And the issue before the New South Wales courts was whether this prevented the court from accepting all of Mr. Nixon's evidence, because as a matter of fairness, Mr. Johnson had not been cross-examined on those 16,000 defects. Now, here's how the court dealt with it. And Justice Tobias said I won't read all of this, but he said, Mr. Johnson in his 13th statement returned to a considerations of Mr. Nixon's reports and expressed the view that the alleged defects described therein were minor and did not prevent the use of the building for its intended purpose. Although there was some cross-examination of Mr. Johnson with respect to the alleged defective wardrobes, etc., none of Mr. Johnson's cross-examination was referenced to any defect disclosed in any of Mr. Nixon's reports, notwithstanding that Mr. Johnson's statements responded in detail to them. So he hadn't been cross-examined in relation to all of these defects, although he had addressed them in his expert reports. And here's what I think is the key bit, where the judge says quite clearly, it would have been a tediously impossible task for the cross-examiner to take Mr. Johnson through each and every defect alleged by Mr. Nixon. It's no criticism of senior counsel for the employer that he did not do so. So what you can see here is a very pragmatic recognition of the impossibility, which is described as tedious impossibility, which I'm sure it would be, of cross-examining an expert on 16,000 defects. So the law recognizes in a very pragmatic way that there are certain things that can be done and certain things that can't be done. And if we're looking at what the big issues are here in relation to these larger cases where there are many issues, well, there are, I think, three of them really, which overlap to a certain extent. One is time. If you can't cross-examine an expert on 16,000 defects in any reasonable amount of time. Second is cost. If you do so, it will cost lots and lots of money. And thirdly, there's the issue of proportionality, which is if you are going to go into detail on certain things, particularly lower value things, it will be a disproportionate exercise because your legal costs will far outweigh the sums in dispute. Now, matters can be different where the sums in dispute are great and you have lots of defects. So it may be a proportionate exercise to go through them in detail. But for smaller matters, then that's not worth doing. So we see this pragmatism in the law, and I think this pragmatism is also reflected in certain statutes and rules in the arbitration context in particular. And you can see on this slide, I've got a reference to the United Kingdom Arbitration Act, which talks about the general duty of the tribunal. And you can see from section 33(1)(a), the tribunal shall act fairly and impartially between the parties. And then B, and this is what I'm referring to now in particular, the tribunal shall adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expense, so as to provide a fair means for the resolution of the matters for it to be determined. So clearly there's an emphasis here on avoiding delay, avoiding cost to the extent it's not necessary, but yet providing a fair way of dealing with a particular dispute. In Hong Kong, you see with the arbitration rules of the HKIE-CDRC, a similar provision actually in Article 13, so 13(1). So subject to these rules, the arbitral tribunal shall adopt suitable procedures for the conduct of the arbitration in order to avoid unnecessary expense delay having regard to the complexity of the issues, the amount in dispute, and the effective use of technology. And then in 13.5, the arbitral tribunal and the parties shall do everything to ensure the fair and efficient conduct of the arbitration. So there are very clear messages here. Avoid unnecessary delay and expense. Conduct the procedure efficiently. It's everyone's duty to do this. And these issues of efficiency and fairness are paramount when we're talking about very large cases with lots and lots of issues to deal with. So how can a court or tribunal deal with these issues? Well, I've identified 3 approaches. I'm not saying these are the only approaches. I'm sure people could come up with other ones. The first one I've called the all-in approach, which is the traditional approach of saying that the claimant or the plaintiff needs to prove all of its claims. So every single claim needs to be the subject or evidence in order for it for the claim to succeed. Now that can be okay when you have smaller claims, not when you have larger cases with thousands and thousands of issues. It would be disproportionate use of time and cost to go through every issue. The second approach I've described as the broad brush approach, which is where the court takes an approach which is like that of a jury, really. It takes a broad view of the evidence and does its best on what is available, what is presented to it, to make a decision without necessarily taking into account all of the evidence. Now, you might say this is a proportionate approach. It leads to an outcome which does not cost a huge amount or an overly huge amount of money and take an extended amount of time. But it may be unsatisfactory in the sense that the court or the tribunal may actually not really consider or not really engage with the issues in the case, some of the key issues. And the third approach, which is what I now want to sort of lead into, is sampling, which is potentially, as I've suggested, a bit more precise than the broad brush approach, because it involves the consideration of a number of different samples of claims. But the success or otherwise of sampling as a technique depends on how the sampling has been undertaken. And there have been some recent cases that consider sampling. I want to refer to those just to see how it can work and how it can fail. So if we're looking at the idea of sampling, is this a relatively new idea? Not really, actually. I mean, it's not an idea that goes back centuries, but it's certainly an idea that goes back to at least the 1980s. And I've got a quote here from Judge Newey QC in the case of Hoskinson and Moody Holmes, where he refers to sampling. He says, nowadays, official referees like him seldom work their way through Scott schedules as orders for selection of representative items for trial are made on summonses for direction. So the technique that was used here was rather than go through the Scott schedule, the judge says to the parties, find some representative items, and we'll look at those at trial. And then he has the comment, parenthetically, I may say that in 8 years, I've only once tried a Scott schedule in detail. I hope not to repeat the experience. Again, coming back to this idea of tedious impossibility when dealing with a multitude of claims. So the idea has been around, and it's being used to a certain extent, but I sense now it's being ramped up a bit in terms of its use, particularly as we're facing larger volumes of data to deal with. Now I want to go further forward in time to a couple of years ago, in a case from Singapore, Ramo and DLE for Justice Chan. This is a case about structural steel and the fabrication of it. And the judge made the comment there that DLE took issue with the fact that Ramo did not provide photographs of every single fabrication defect. However, I note it is not strictly necessary for Ramo to measure and provide photographs of every single defect. To require it to do so would result in an unreasonably onerous burden of proof. And then the judge refers to the case of Millennia, where the High Court of Singapore accepted evidence of witnesses' testimony on the number of oversized pinholes in the panels, who had measured the pinholes on 81 out of 240 panels and extrapolated from the sample. Such a pragmatic approach will similarly be adopted in the present case. So here the judge endorses the idea of sampling as a proportionate and pragmatic exercise. So that gives us a clue as to where the courts are heading in relation to sampling. Now I want to go to a case which went to the English Court of Appeal from last year, which I think is still a live case. And this is BDP and Standard Life, where Lord Justice Coulson, who you see there, was dealing with a case where there were lots of claims, particularly for variations. So he says it's not an issue that in an appropriate case, sampling and extrapolation is an appropriate tool by which the parties and the court can organize the evidence and try the issues in a proportionate way. It's worth noting that in this case, with in excess of 3,500 variations potentially an issue, the court would inevitably have dealt with the claims by way of sampling and extrapolation. However, the claims had been pleaded. And then he goes on to say later on, says, as a matter of pleading in an appropriate case, a claimant can plead an extrapolated claim. But then he adds this note, which I've highlighted. He said, such claims can be particularly difficult to establish. So there's an endorsement here to the use of sampling and extrapolation as a proportion exercise, but the judge gives a note of caution that these claims can actually be difficult to prove. And why might that be the case? Well, I won't give a comprehensive list of potential problems, but let's just look at two of them. And one might be that the sample taken is not representative of the whole set of the whole population of data. So let's say you have 2,000 variations which are instructed, and they relate to various aspects of the work. Some relate to foundations, some to structural steel, and some to architectural finishes. If you have a sample of 100 taken of those variations, and most of them relate to the foundations and not to the structural steel or the architectural finishes, is that a useful sample? It might give you a good idea in relation to the foundations variations, but it may be completely misleading in relation to the other variations for the structural steel and the architectural finishes. So it's important that the sample taken is something that can truly be extrapolated to the whole. And one way a claimant can do that, and it really needs to do that, is by using things like random selection from the pool of variations or whatever it is, to avoid the suggestion that the sample has somehow been skewed in the claimant's favor or in a particular way. Now, a second example that I've given here is where you have lack of homogeneity within a sampled population. So you might have, say, 2,000 variations which have been instructed where there's a dispute over them as to whether they're actually variations, and if so, what the adjustment to the contract price should be. Now, what if each variation is actually unique? It turns on its particular circumstances, and then you don't have any sort of common elements or fact patterns within the or amongst the variations. How is it possible? How can you say, I can take a sample of them and then extrapolate them out, and that will be accurate? Because if each variation is unique, then that doesn't provide a basis for extrapolation. So maybe as a further consideration, a claimant would need to demonstrate that there is homogeneity amongst what is being looked at. And if that is done, then maybe sampling is permissible. So what can we conclude from this in relation to sampling? I think we can certainly say that sampling may indeed be an acceptable method of pleading and proving a claim. But the law doesn't prohibit the use of sampling, just as it doesn't prohibit the use of global claims for delay. And those of you who are of a certain age may well remember that over the last 30 years or so, there have been a number of cases dealing with a similar issue in relation to global claims. Can you have a global claim? Is it permissible? The courts have generally said, yes, you can, but it can, perhaps like a claim based on sampling, it can be difficult to prove. And we still have issues to be worked out here by the courts. And I've just raised a couple here, and there could be many others in relation to sampling. A threshold one, it seems to me, is when is sampling actually permissible? So what is the threshold for using sampling? So let's say you have a case that involves 100 claims, for example, 100 variations. Is it permissible to sample, say, 10 of them and then extrapolate to 100? Or do you need a greater number? If so, what is that number? Is it 200? Is it 500? Is it 2,000? These sorts of issues need to be examined. And a second key issue, really, is how sampling is to be undertaken and demonstrated as a matter of evidence, because the law is not prescriptive about this. And what we may actually see, and have seen at least in one case, is the use of a new type of expert in construction and engineering cases, a statistical expert. So we're used to having delay experts, quantum experts, perhaps technical experts, and we can have statistical experts as well now. This was the case in Amy and Cumbria, which I've mentioned here. This was a TCC case in England, which involved potholes in Cumbria, which were ordered by the council for the contractor to fix. There were about 1,700 works orders placed, 116 orders were sampled, and the court held this was insufficient sample size. Now, the point I want to raise here is really that if the idea of sampling is to try to reduce the overall cost and time of dealing with a particular case or set of issues, might it paradoxically actually add to cost and time, because we have this new type of expert who is involved in the case, who deals with the sampling exercise. So that's another thing for us all to consider. And a further thing for us to consider is whether, when we're drafting contracts and negotiating contracts, we can preempt some of these issues. And I've given an example from the offshore wind context in relation to defects and how this is addressed in contracts. So we often see serial defects clauses, which can be expressed in a number of ways, which basically deems there to be a serial defect if there are a certain number of occurrences of a type of defect during a defects warranty period. And by having this clause which deems defects to exist in insufficient quantity so as to be a serial defect, thus requiring the contractor to remedy the defects, this can overcome actually some of the issues, at least presumptions relating to the incidence of defects and the need to prove the existence of defects. So we have contractual options available to us, and maybe we also have technological solutions too. I don't profess to have any great expertise in relation to technology. In fact, I haven't really managed to get the slideshow to work properly, so that gives you a measure of things on my part. But it seems to me that conceptually, if we're now living in a world where we have lots of data, all electronic or mostly electronic, and we have very powerful computers, can we find ways of using that technology to actually crunch through a lot of these issues, so that maybe the computers can use sampling, maybe that the computers can analyze claims using artificial intelligence or otherwise. I don't want to talk myself out of a job, but who knows, maybe in the future we'll have robo judges and robo arbitrators and even robo lawyers that can crunch through the data to come up with the right answer. So to sum up, to draw the threads together, as it were, in relation to these issues, what can we say about large projects and disputes? So I think we can say fairly clearly that we need to come up with pragmatic solutions to keep the time and the cost of large projects and disputes within proper bounds, to keep things proportionate. The second thing we can say is that the law and legal processes, including arbitration processes, they're quite flexible. So we have many options available to us, that both courts and arbitrators. And what we can do is we can use that flexibility to keep disputes proportionate in terms of time and costs. So we're not straitjacketed in terms of how we deal with large claims with many thousands of different items. The third thing that I'll say and conclude on is that sampling has certainly emerged in recent years as an important way of delivering proportionality for these large construction engineering projects. But sampling is still a fairly new sort of a beast in the world of construction disputes. And so its application in practice is still to be worked out. So there could be many more things to come in relation to sampling, and I urge you to stay tuned. So I will conclude there. Thank you very much.
Thank you, Julian. Thank you for talking with us about this interesting topic. And there are some questions from the attendees. And the first one is, contemporaneous documents are plentiful in large construction disputes. Would factual witness be necessary for dispute resolution?
Yeah, well, this is an important issue, and it's an issue that courts and arbitrators are grappling with in many different jurisdictions. If a case turns on what the documents say, why do you need a witness to go through the documents? That's a perfectly valid point. And I think it's a point that's led to frustration, certainly in the English courts. And in relatively recent times, the English court rules have actually changed to say that witness statements are not allowed to consist of a witness going through all of the documents. And the courts really don't want that and won't permit that to occur. So I think that there's much to be said, actually, where there's no issue about the documents themselves, whether they're fraudulently prepared or something like that. If the documents represent the project record of who has said what, then I think it's often acceptable for those documents to be relied upon. Now, this doesn't necessarily do away with the need for factual witnesses, because it may do away with the need for lengthy witness statements, but it may still require, as a matter of fairness, and to get to the bottom of things, the people who wrote those documents to be there in court or in arbitration to answer questions about them, questions which may emerge from the documents. So I think, look, there's certainly much scope for reducing witness statements, because if the documents tell the story, but we will still need factual witnesses to be there to answer the tricky questions about what actually happened.
I see. So that's based on fairness. The next question is about from civil justice reform. Of course, we are talking about civil justice reform in Hong Kong back in 2001. Single joint expert is now highly promoted by the court. And in fact, in some local arbitration cases, they also promote the use of single joint expert. Now, what is your view on the subject, especially now we're talking about voluminous amount of VOs, for example, which are in dispute? Then, of course, if you are having a single joint expert, that may save a lot of argument. What is your view towards this matter?
No, thank you. Look, I think if you look at the concept of a single joint expert, it's actually a really good concept, because you might have a judge or even an arbitrator who can't or doesn't necessarily have the technical expertise or the time to go through all the key issues, say, related to 2,000 variations or whatever it is. If a person, such as a single joint expert, can be appointed to go through all those issues and present a report to the judge or the arbitrator, that can be an efficient way of dealing with things. Maybe the single joint expert is entitled to use sampling or maybe not. So the court or the tribunal gets the benefit of having an independent person assisting them in resolving the key issues. But I think that's the concept. I think the practice and the reality doesn't necessarily lead to a proportionate and cost and time efficient outcome. Why do I say that? Because what often happens with single joint experts is the court, in the case of the court, will appoint an expert, but then the parties themselves will have their own experts to prepare information for the single joint expert to be submitted to that person. So having a single joint expert doesn't necessarily do away with the need for the parties appointing their own experts. So you still have that layer of cost associated with expert witnesses. I think it's a good idea, but I think it's not something that always works in practice.
Yes, I see. The last question is on you have mentioned about the rough justice and sampling as some way of dealing with the problems encountered in the large dispute. One of my experience in a construction case is that we have this case before the construction judge, and there are a number of variation orders. And the commercial judge told us that, this is a commercial court, we have to be commercial. So for any variations, of course, we are talking about a huge number of this. If the amount is, for example, less than $1,000 US, you just split the difference. No need to trouble the court. Is this what the so-called rough justice you are talking about? Or, do you think that will be a sensible way of dealing with this?
Look, I think it can be a fair way of dealing with claims of a particular value, because the question is, what if you don't have that? If you have claims that are worth, say, less than $1,000, and you've got lots of them, how do you deal with it? Well, you need factual evidence. You need expert evidence. You need witnesses giving evidence who will be cross-examined on these matters. And so you can quickly have a situation where, let's say that the variation is worth $1,000, where the legal costs of dealing with that variation could be 10 times that or more, I don't know. And so I think one has to come up with measures that lead to cost and time being proportionate. And I can see that, the good sense, the pragmatic sense of taking that approach, even though as a matter of accuracy, it doesn't lead to necessarily to the right result. It's splitting the difference. It's fairly arbitrary.
Thank you. Thank you very much, Julian, for sharing with us your thoughts and also your knowledge and experience in this area. We are much benefit from what you have just talked to us. Thank you so much. So I will ask the attendees.
Thank you. It's my pleasure.
Thank you.